We're going to start, obviously today, as we said, it's grievances and disciplinaries. We're going to start off with a grievance. So basically, what is a grievance? Well, a grievance basically is where an employee has a problem at work. This can be pretty much really anything. It can be to do with their role, or it can be to do with another colleague, or it can be to do with just general conditions that have that they've got. Those of you, just doing a bit of self-promotion here, those of you who are using our Church of Scotland employment templates, which I think the majority of you are doing now, Schedule 3 of those contracts sets out a template grievance procedure, which the employee will have to follow if they're wanting to raise a grievance. So just putting that out there now, and obviously these slides cover those points too. So grievance, there's really two types of grievance you can raise. You can either raise an informal grievance or a formal grievance. As the slides say here, even if the grievance is raised informally, the employer should respond to the grievance. It's not a matter of simply, just listening to it. It should be, the employee should take steps to address it. I suppose maybe the difference between if something is raised formally or informally is possibly the grievance could be addressed simply by the employee or the staff member, verbally, whereas you would often find that if it's a more formal grievance, the appropriate course of action would be for the employer to investigate the grievance and then give the employee something back in writing. And just jumping to the last bullet point here. So basically, grievance. Yeah, the grievance procedure, which and this is the one that's set out in our contract, is a formal way for an employee to raise a problem or a complaint to their employer. So, if we go to the next slide, Natasha, yep, we've kind of touched a little bit on this. When can an employee raise a grievance? A formal grievance. Formal grievance can be raised if, for instance, you've raised it informally, and this does happen quite frequently. If perhaps, for instance, classic example of where a grievance might be raised is if you've got an issue maybe with who's line managing you, you might raise that informally initially to say something like, I don't think they're treating me very well or whatever. And if the informal resolution that the employer's adopted hasn't worked, then you can obviously deal with it more formally by raising a formal grievance. If we can jump maybe to the next slide, Natasha, thanks. So, following a formal procedure, if an employee raises a formal grievance, you should follow a formal procedure. Now, as I say, hopefully life will have been made easier for you, because if you're using the template contracts that we have produced as a department, you won't actually have to create your own formal procedure. The formal procedure for the grievance is set out in that Schedule 3. Very important point with a grievance, and as we'll see with disciplinaries, employees should obviously raise the grievance as soon as they can and take any actions of them as soon as they can. So, if an employee has got a grievance, or mentions they've got a grievance, we should be encouraging them to raise the issue as quickly and fairly as they can. So, the next slide, Natasha, please, is one probably focus on a little bit more, because this is probably more relevant to you guys as well. So, you've got a situation where you have got a grievance in from an employee. Grievances, when they come in, should be dealt with efficiently by an employer. It's very tempting, and I know some of you on the call may have already dealt with a grievance with an employee or a disciplinary matter. It's very easy when these matters come in. You're busy trying to do your job. You've got other things to do, especially if something happens around a time of year like this, where obviously not only are you busy with your personal lives, you've obviously got busy work life and other stuff going on. But the theme that very much, if there's probably one point that you take away from today's training, is if you are presented with a grievance or a discipline or something disciplinary comes to your attention in respect of an employee, whilst the temptation is to sort of put it in a drawer and close it, I would always recommend that you deal with it as quickly as you reasonably can. Unfortunately, it's not a case of the problem's going to go away or the disciplinary issue is just going to disappear if you don't deal with it. Always try and deal with it as quickly as you can. So, sort of set out here more kind of fundamental points. Duty on the employer. Employers should make clear to the employee that they'll deal with grievances fairly and consistently. The grievance should be investigated. How you investigate the grievance will obviously depend upon what the grievance is. If it's to do with the behaviour of colleagues, you might need to meet with the other colleagues and speak to them. Or if it's to do with volume of work or how they're getting the work on a system, you might need to have a look at that. It may well mean that various other things need to be looked at as well. So when you're doing a grievance, certainly if it's a formal grievance, you should always have a grievance meeting with the employee. This is kind of set out again in our Schedule 3 of the contract. So once you have received an employee grievance, you need to investigate the grievance, and you should always have a meeting with the employee after it to discuss what you've investigated and what you've found. So if we go to the next, yep, thanks, Natasha. So, yep, points here, these last ones as well. Everyone should have a chance to have their say before making a decision. So this is obviously particularly important in cases where you have possibly an employee who is upset about maybe their line manager's behaviour. When you're investigating the grievance fairly, you obviously need to speak to and discuss the matter with the person who's raised the grievance, but equally, you need to speak to the line manager, get their take on it as well. For instance, if the employee's saying, "Oh, my line manager bullies me, or doesn't listen to me, or treats me badly," obviously, it's only fair that in looking at the grievance, you factor in the other side of the story as well. And yep, as I've said, take action and make decisions as soon as you can. Absolutely, with these things, when a grievance comes in, I mean, say a grievance came in today, hypothetically, I mean, it would be ideal if you could try and maybe meet with the employee a week today, if that gives you sufficient time to investigate it. Always try and deal with these things as quickly as you can. And when you've dealt with the grievance, we'll probably come on to look at this in a little bit more detail later on, but you'll often write to the employee after the grievance has been raised with the outcome of the grievance. It's important that to ensure the process is fair, that you say in your letter when you are setting out your decision with regards to grievance, that the employee can appeal that decision if they're not happy with it. So, for instance, using our bullying example with the line manager you've got, if the employee says, "Joe Blogg's my line manager, he bullies me at work, he treats me differently to another member of staff, he's much more strict with my deadlines than anyone else's." If the employer investigates that and finds that that's not the case at all, Joe Blogs treats everyone the same, he nags everyone to make sure things are on time, the employee, if they disagree, should be able to have a right of appeal of that decision to someone else, just to check that the correct decision has in fact been reached. Thanks, Natasha, for moving me on. Yes, another. I mean, this is kind of relevant mediation. Obviously, the slide kind of suggests that you're dealing possibly with a much larger organisation, but if a grievance is raised, one option, of course, is if you think the circumstances would suit it, or you the person who's raised the grievance is of a mind, you could try a sort of mediatory approach to resolving the grievance, that might work. For instance, if it's to do with sometimes it's quite a good idea if it is sort of to do with one employee and another, because at the end of the day, thinking ahead, if an employee raises a grievance about another employee and the grievance is upheld, still, the likelihood is that these two individuals are still going to have to work together. And I think with the best will in the world, you're never going to have a very good working relationship with someone who has raised a grievance against you, even if the actual grievance is upheld. I mean, it may well be, again, in our example that we've been using, that Joe Bloggs has been treating this other employee unfairly. But at the end of the day, something to bear in mind is, of course, that Joe Bloggs and this other employee are still going to have to work together, even if the employee can have a sense of pride on his back that his grievance has been upheld. At the end of the day, they've still got to work together, and that's something to bear in mind. So possibly, if you think mediation might be, or a kind of approach where you as the employee sit and work together with the two employees, that might be something that you want to have a think about as well. So, yeah, this I think we will maybe just quickly whiz over this, because this is much more how an employee can raise a grievance. This is much more reference point for you guys as to what to expect. But obviously, how an employee can raise a grievance is set out in Schedule 3 of our contract. But basically, they should put it in writing. You would expect the grievance to be in writing, and I think if an employee does come to you and say they want to raise a grievance, and you think it is something that's maybe got a bit of meat to it, or you will have to, the matter presents itself as something potentially quite serious, then you should ask the employee, just because of the nature of the issue, to put something in writing. And as I've said here, they should see what the grievance is about. Obviously, the last bullet point's probably worth focusing on. Yes, with a grievance, it's one thing for an employee to raise a grievance. The employee says, "Oh yes, Joe Bloggs has been bullying me at work. He keeps on, he checks my emails all the time, and he checks what my output is, etc., or not what I'm doing." An important thing for an employee in a grievance to do is, as this last bullet point, say, what do you want the employer to do? So that should be something there. So, for instance, in our example, it might well be that if the line management relationship isn't working, the employee might want a new line manager, or they might simply want the person above that line manager. Probably in our example, it might well be something like or the minister of the church, somebody else to maybe have a bit of input. But the employee's grievance should say what they're actually, put it in very straightforward terms, what their complaint is and what resolution they're looking for at the end of the day. So, responding to a formal grievance. Obviously, it goes without saying, with all these things, you should keep written notes, written records of what takes place during a grievance procedure and who you speak to. I'm sure you probably all do that anyway with all your HR things, or just keep a file note or whatever. You should keep a note about what the grievance is about. Pretty obvious. Keep a note of your decision making in relation to that. For instance, just using our example of the bullying scenario that we've been using throughout this training session, you should sort of say, if you decide the line manager isn't a bully, you should sort of set out the reasons why you think that is the case. For instance, if you can't see any visible signs of it, or they treat everyone the same, keep a note of all your action points, and obviously as well, note the outcome, and if the employee is determined or not to make an appeal or not regarding the matter. So, Yeah, I've put in a separate slide about this because grievances, it's obviously if the grievance is about someone at work, obviously the grievance isn't going to be about someone who's not at work. But I suppose what I meant with that slide is the grievance isn't about your working conditions. Very often or not, you're not going to raise, say for instance, your working hours are something like 9 till 5, you're unlikely to raise a grievance because you've got to come in at 9 o'clock in the morning. You're probably more likely to go and speak to your line manager or someone about varying your hours or having flexible working or something like that. Grievances, by their very nature, tend to be about people, which is obviously why I've sort of focused that more often or not. All the grievances I've dealt with, I think I would say at least 95%, and certainly most of the grievances I've dealt with in my role in the COS have always involved people not getting on with other people, which is often the basis of a grievance. I've just stated as well, obviously, gather as much information as you can. And point two is very relevant. Be sensitive to the circumstances in as much as you're able to do so. I mean, we're all guilty of when we get complaints or things that are put our way, maybe on our assessment of them, they are fairly trivial matters, or you think to yourself, for goodness sake, why is this person raising a grievance? But obviously, if they have gone through any kind of informal or formal grievance procedure, it matters to them. So whilst you may well consider it a bit of a bugbear having to spend your time looking at it, do try your very best to be sensitive about it. Suffice to say, just before we move on to talk about disciplinaries, if anyone does raise a grievance and you want guidance, these notes are intended to be, a go-to for the initial stages, or you just think, right, don't know what to do, and it will give you a starter for 10. But obviously, if someone's got a serious grievance or something, please do come and ask. I mean, as I've kind of indicated throughout all these training sessions, these slides and this training is no substitute for you seeking formal advice in relation to anything. So obviously, if that happens, please do come and let me know. So I think we will, if we can jump a couple of slides, Natasha, just because I'm conscious people are, could we jump another, please, to the grievance meeting? I'm conscious people have, I think that's, yeah, perfect. I'm conscious people are a little bit tight for time today, so I want to just kind of do the most important ones. Obviously, there's lots of other information in there, as I've said as well. So, the grievance meeting, yes, as I've said, when a grievance is raised by an employee and it's been investigated, you should meet with the employee to discuss the grievance and go over what the grievance is. And I've said here, when an employee raises a formal grievance, the employer should arrange to hold a meeting within 5 working days, ideally. So that's quite a quick time scale. I mean, for these things to be kind of done in, but grievances should be dealt with quickly. Obviously, at this time of year, it does present difficulties. And in fact, I have a congregation that I'm assisting with a grievance matter at the moment, and clearly the minister's hugely busy just with their commitments at this time of year because of Christmas, and other people have got, similarly to yourselves, lunches and dues and more fun things to do, and fitting time in to deal with this is difficult. But in as much as you can, try and hold these grievance meetings as quickly as you can. And basically, employers should allow employees enough time to prepare for any meetings, and the employer can arrange for someone not involved in the grievance to take notes of the meeting or act as a witness if necessary. Very valid point here, and something that any of you who have dealt with grievance or disciplinary matters will know. Never do these things as a solo effort. Always have someone there with you who can be usually a note taker if you're leading the discussion. But it's always beneficial to have a second pair of ears and eyes at these things, just in case following the meeting, there's another complaint raised, and it's a case of you've got one person's word against another. It's always helpful for the employer to have someone else along as well. So, yep. Again, more here in the grievance meeting. I'll whiz through these bits because they're very clear, but just really for reference. Grievance meeting: keep the procedure fair. The employer should consider information from all sides. Of course, you need to listen to if it's a he said she said scenario in the employment case. Obviously, you need to hear what everyone's got to say about it. This is a valid point and something that you do need to maybe bear in mind. If a similar grievance has happened before, you should follow the same procedure. So, for instance, if it's maybe to do, if the grievance is, more of a grievance to do with how your working conditions are, right? I mean, this wouldn't really apply so much in terms of an individual, but if you've got 3 employees, one person's raised a grievance about something, and the grievance was upheld, and a certain course of action was followed. To ensure consistency with your decision making, you should you should use past grievances as guidance or how you've acted to help with your decision making. So if it would be if 2 employees, I suppose the point I'm trying to make is if 2 employees raise similar grievances, the outcomes should be, if it's to do with like working conditions, the outcome should be very similar for both. It shouldn't be a case that one person is getting treated differently to another, unless, of course, the circumstances of the case are hugely different. But it's to ensure a sort of consistent approach. This is quite an important point, and something which, again, if there's ever going to be any kind of takeaways from today's training, deal with disciplinaries. Takeaway number 1 for today would be deal with these matters quickly, disciplinaries or grievances. But the second point that is incredibly important is what we call the right to be accompanied. Now, if you are dealing with a grievance or a disciplinary matter concerning an employee, the individual who's raised this ground has got a statutory right to be accompanied to these meetings. And if you don't give them that opportunity, if the case were to eventually go to an employment tribunal might find that the process was unfair because this option wasn't given to the employee. So this is quite an important takeaway from today's point. Again, if you're in that situation, I will obviously guide you on that. But this is kind of set out here in quite copious detail in the slides. The employee has got a right to be accompanied. Now, your right to be accompanied doesn't mean you can just pick anyone you want to come along to these meetings. It really should be a work colleague, a trade union representative, or somebody officially employed by a trade union. The reality in our kind of congregational church setting is we're not very, I would have thought very few people are members of trade unions, and that tends to be not very appropriate in our circumstances. The other difficulty is as well, I suppose, in congregational contexts is there are so few employees. It's very difficult, if you've only got 2 employees and someone's bringing a grievance, you might not want that other person to know what your grievance is. I mean, for instance, in the central services where I work, there's about 200 members of staff. If I had a grievance about my department, I could ask somebody in the faith action team or the safeguarding team, who obviously I work with, but I don't work with sort of shoulder to shoulder, to come and accompany me to the meeting without it being necessarily one of the other lawyers in my team, because the grievance might be sort of something that I've raised that's personal to me that I wouldn't really want someone so closely working to me to know about. So, I mean, I have quite the few grievances I've dealt with in the church, quite often or not. it's resulted in the person who's bringing the grievance bringing along their partner or their husband or their wife. I mean, it's a slightly unusual choice, but my own view on who you bring along, provided the person is not is not going to in any way be controversial. I usually am fairly reasonable in whom I would allow a person to bring along to accompany them. Strictly speaking, in terms of the law, as I say in the slide, it really should be a colleague or a trade union representative. But if I had one case actually where someone wanted to bring their mum along, which I mean. Between you and me, a slightly odd choice, but at the end of the day, couldn't really see any legal basis or any ground why having their mother there would be inappropriate or cause any problems to the process. So we eventually just agreed to let it happen, and that person brought their mother along to their grievance hearing. So something to bear in mind, but the important point to take away is you have a right to be accompanied. So the employee must be told about that in terms of any grievance and as we'll come on to, disciplinary action as well. Deciding on the outcome. So, yes, after you have had your investigation meeting, conducted your investigations, you need to decide on the outcome of the grievance. Basically, you need to decide if you're going to uphold the grievance or you are not going to uphold the grievance. As I have said, you've obviously got your findings and your notes from the investigation you've done. Your decision that you make in terms of upholding the grievance should be based on what you consider to be fair and reasonable. And we've touched on the last point already. Have similar things happen in the work scenario before. So, for instance, I'm trying to think of an example. An example might well be, obviously, if I was involved in a grievance, not here, but somewhere, at previous employers, where this person worked a 9-to-5 job and they had an hour off for lunch. They raised a grievance because what they wanted was they wanted only to get a half-hour lunch and finish at 4:30. So the 30 minutes was going to be deducted from their end time. They wanted a shorter lunch to have an earlier finish. And the employer said, no, we're not going to give you that because actually, first and foremost, when you took the job, you knew it was a 9-to-5 job. Secondly, the reason why you get an hour off for lunch is because it is for, your mental health and well-being. You should have an hour away from, the screen or your desk to rest, eat, recharge your batteries, go for a walk or whatever. It's good for you. The difficulty the employer had, though, in this particular case that I gave them advice on was, and the employee was very quick to comment on this, is that there was another employee who had put in a similar request and it was granted. So, whilst the employer was saying on the one hand, yes, you should have an hour off because the reason why, the hour off is there for a reason, it's to give you a break. The difficulty was that the employer didn't apply that line of thinking when they were dealing with another employee. So they only had a half-hour lunch. So in fact, at the end of the day, what happened was this employee's grievance was upheld. But again, what that really highlights is the importance of being aware of decisions that you've made before in relation to similar matters. So, if you're going to say that you've got to have an hour's lunch break, make sure that applies to absolutely everybody, or in similar circumstances, it shouldn't be that one person is hugely different than another. So, deciding the outcome. Employer should tell the employee of the outcome as soon as possible and in writing. Again, that is very important. Without a doubt, put your grievance outcome in writing. And I'm happy to read your responses to that because, the outcome of, if the employee is unhappy with the outcome that's been given to them in writing, they might decide to take that further, and we want to make sure what's in writing is very clear and sets out precisely our thoughts and processes behind why we have reached our decision. And quickly, just looking at right of appeal, as I've said, the employee should be told that if they're unhappy with how their grievance is decided, they have a right of appeal, and basically the appeal grounds for the employee really should be if they think the process was unfair, or they don't think that the outcome has been appropriately resolved. So a very much a whistle-stop tour, everybody, of grievances. But as I say, grievances, if you do get the employee days in one, please come and speak to me. The notes are very detailed, and hopefully they are, if you need to get a read through the various steps, but I just don't want to, I'm conscious that we are time critical in terms of what we're going to deliver in these sessions, and I know some of you today even more so with having other fun stuff to do. So without further ado, we'll move on to everybody's favourite topic, disciplinary procedure. Why would you want to do that? Basically, disciplinary, as the note says, is a formal way for an employer to deal with an employee. Two grounds that you would consider taking disciplinary action for against an employee. The first one is the classic one. That's where their behaviour or their conduct is unacceptable. For instance, if they're turning up late at work, or if they're not doing or if they're swearing at their line manager, or basically behavioural matters. And then the one that people probably don't know quite so much about, but you can take disciplinary action, or what we more classically call capability action, against an employee if their performance in the role. So for instance, that may be where you have maybe a church administrator or church secretary or something, and they're as polite and as pleasant as they can be, but they're just not very good at their job. So you can take action against them in that form as well, by way of capability. So we're going to look first and foremost at capability issues. So capability route. This is, as I've said, where concerns are raised by an employee about their ability to do their job. Capability, if an employee is put on a capability procedure, without a doubt, their first instinct is to regard that as punitive, and that their employer is doing something unpleasant against them. But in fact, whether this is actually strictly true or not is I think is a bit of a moot point. But capability is in fact supposed to be seen as the employer supporting the employee, and trying to encourage them to improve and do their job better. So for instance, if you are dealing with that, say for instance, it's to deal with if capability is about someone, maybe if you've got a church secretary and their timekeeping is not very good, you might kind of set them structured objectives and deadlines in terms of to meet those deadlines, and that would hopefully be something they could achieve, and the process would be a success. So, thanks, Natasha, for flipping it on. If we just go back one slide, please. Thanks. Thank you very much. So this one is the more classic issue of why you take disciplinary action against someone, and that's often to do with how their conduct is. And basically, is misconduct. Is this where an employee's inappropriate behaviour or action breaks workplace rules? So there are varying degrees of that. Some examples I've given are here. Issues of bullying, harassment, refusing to do work, or being absent without permission are examples of where you might take action against the employee. If we go on to the next slide, Natasha, thanks. Yes, so you've obviously different levels of conduct. I mean, strictly speaking, if an employee is late to work every single day, 10 minutes late every day, that could amount to disciplinary action, but it's probably unlikely to amount to what would be determined as serious disciplinary action. But these cases do arise, and we refer to these in employment context as the employee's conduct is gross misconduct. And as this note says here, some acts count as gross misconduct because they're very serious or of very serious effects. If an employer finds there's been gross misconduct, they should carry out a full investigation and full disciplinary procedure. Examples of gross misconduct might be if you turn up to your employment under the influence of alcohol or drugs, or if you have been convicted of a serious criminal offence, or you have committed fraud against your employer or something like that, that would probably be something that could be classed as gross misconduct. The main thing, and we'll no doubt come on to look at it further on in the slides, the main thing with gross misconduct is if you are potentially facing a disciplinary action of gross misconduct, that there is a possibility that you might lose your employment. So that's the fundamental difference between gross misconduct. And I mean, it's very unlikely if, you've got an employee who walks in at 9:15 every day as opposed to 9 o'clock, that the employer might, well, that's not good enough, we'll take some sort of action or whatever. But it's unlikely that type of conduct really, certainly in the first instance, is going to merit being disciplined for gross misconduct. But obviously, if there is repeated behaviour of those lines and it's sufficiently serious, gross misconduct can be something the employer will think about. So, on to the next slide, please, Natasha. Thanks. This is very important in terms of dealing with any disciplinary matter. And again, it's probably one of the other takeaways from today, along with dealing with things quickly and the right to be accompanied. Follow fair procedures. So if an employer has considered trying to resolve the issue informally but feels they need to start a disciplinary procedure, they need to tell the employee that they're doing this. And you should write to the employee saying that their what the alleged offence is. If it's bullying or harassment at work, failure to turn up, or whatever the matter is, and you should indicate to them in the letter that you write to them what a potential sanction for their behaviour might be. This is particularly important where the sanction might be that they will be dismissed because what they have been found or potentially might be found guilty of is gross misconduct. I have numerous style letters that I can give you to complete for these types of things. So if you feel that if you feel that you are in this situation and you would like style letters, please come and have a discussion with me, and I can give you style letters to deal with all of this, because they inevitably, if there is any follow-on employment tribunal, the employment tribunal will scrutinise the process that you've followed. So it's important that we have all these things done properly. If we look at the next slide, Natasha, thanks. Yes, if you're going to take disciplinary action against the employee, very important, the employee should have information and time to prepare for the disciplinary meeting. So if you it would not be fair and appropriate to write to an employee today and say to the employee, excuse me, that you've been bullying and harassing a colleague. We want a disciplinary hearing tomorrow. Excuse me, that would not give the employee sufficient time. It would probably be more appropriate to deal with that following fair procedures, etc., etc. And the last slide pretty much surmises the position. The employer must make sure they follow a full and fair procedure throughout the process. So, yes, so you have you are the employer, or you are presented with a disciplinary matter. You may require to carry out an investigation. In some circumstances, you might not need to investigate the matter, but in some circumstances, you will need to investigate the disciplinary offence. My own view with these things is that if you think the matter is sufficiently serious, and it might result in the employee being dismissed or some serious sanction being given, I would always recommend that you do carry out some sort of investigation. It will put you in good stead if the employee does decide to take you to an employment tribunal, because you can document what investigation you've done. I mean, it may well be on the face of it that you have everything you need and you don't want to investigate it, but without a doubt, if you're in an employment tribunal, a query that might be raised by the employee is, did you investigate it? And if obviously you've conducted an investigation and you've got a note of the investigation and things you've found out, you will be in a far better position in terms of being able to show that you followed a full and fair process. When you're doing the investigation, these things are fairly standard points that I've said. Obviously, you meet with the employees, and if it's to do with matters and you feel it's appropriate to take a statement, then do so. So, lovely. So, yeah, we can go on to the next one, please, Natasha. Thanks. So, yeah, the disciplinary hearing itself. So, if you decide to take disciplinary action against the employee will should be invited by you to attend a disciplinary hearing. Again, as one of today's takeaway points, disciplinary hearings should be dealt with as quickly as they can after investigation, and you should arrange for the disciplinary hearing to be held pretty quickly, but obviously, even within that period, the employee must be given a reasonable time to prepare for the disciplinary hearing. So, in the analogous example I gave, it wouldn't be appropriate for a disciplinary email or letter to go to an employee today saying, we've received allegations that you're bullying so-and-so, the meeting's tomorrow, because the employee won't have sufficient time to get themselves together, but maybe a week from today would be fine. Everything, again, should be put in writing, and obviously I've sort of set out the bullet points here about the alleged misconduct issue, investigation, etc. Basically, you really do want to try and give the employee as much information as you can about what information you've got. So, if that's something like CCTV or time recording sheets or something like that, but you do always want to set out for the employee, photographs, whatever, you always want to set out to the employee what evidence you have got in support of the allegation that this person's committed any kind of disciplinary offence. The next slide. Yep, touched on this already. Obviously, you're going to tell the employee when the disciplinary hearing is going to take place, date, time, and location. Again, one of the important points: employees get a right to be accompanied to a disciplinary hearing, and you should let the employee know what possible outcomes of that will be. This is particularly important, again, as I say, where you might be dealing with a matter of gross misconduct and the employee might be subject to what we call summary dismissal or dismissal without notice. They're simply told, your conduct so bad, we are terminating the employee relationship as of this meeting. So they should be told that in advance. Right to be accompanied. Similarly to grievances, it should really be a work colleague or a trade union rep. Again, though, in the context in which we were working in here with congregations, etc., I would let I had a congregation in the north, or I'm trying to remember what it was. I think it was in the northwest somewhere, who were going through a disciplinary process, and they were asking, for me to sort of affirm the person. They were wanting to bring, I think, a best friend or something with them. I mean, strictly speaking, you could be very difficult and say, well, no, it should be a colleague or a union rep. That's what the legislation suggests it should be. But my own view with these things is be pragmatic about it, and provided the person is not going to jeopardise the process, then that shouldn't be a problem. I suppose couple of points maybe just to make on that, because the right to be accompanied is similar to that with grievances. A couple of other points maybe just to throw in here. The person shouldn't be bringing along another solicitor, like a solicitor. That would be something that we would be objecting to. Now, the likelihood is probably the solicitor would tell them it's not appropriate. They came along. But if you are going to discipline an employee, and it so happens, I've got a friend who's a solicitor, we could, they should tell us in advance of the disciplinary hearing who's going to be coming with them. And I mean, for instance, if they were going to bring a solicitor along who was going to act in a solicitor capacity, I think we would probably have reasonable grounds to object to that as being someone who is not appropriate to come and attend, because obviously they're giving the person advice, which they're not supposed to be doing at this stage. It's simply a right to be accompanied, not a right to have advice. So that point would be careful. Another point that I suppose much more in the church context is valid is maybe, if people want to bring along church elders or something as the right to be accompanied, again, I think there just needs to maybe be a careful thought whether that person is being conflicted in coming along, because this is what a situation I actually had was, can't remember which church it was in, but someone was being put through a disciplinary process. This was another case where they wanted to bring their mum along, and we thought, well, fair enough. As I've said, it wasn't that unreasonable, but we had to be careful in this instance, because actually the mum was actually an elder, and obviously as an elder and trustee and a member of the session, she may well have potentially had some input into how the decision making was done, because obviously the employer is the Kirk session. So you sometimes just have to be very careful about who the people bring along. And I mean, obviously, if I mean, in this particular case, we did allow the girl who was being disciplined to bring her mum along as the accompanying person. But in terms of any decision making, we had to make sure that in any kind of voting or whatever, that the elder member didn't get a chance to participate in the process or whatever, because obviously she was conflicted coming along to the earlier meeting, so she couldn't be involved in deciding what disciplinary action was going to be taken against her daughter. So just little points like that. Again, though, if you are faced with these obstacles, I will happily, provide you with support and guidance to tell you what would be appropriate or not. But they're just a couple of things that I thought might be worth flagging up. The hearing is a chance for both the employer and the employer, to state their case. So in a disciplinary hearing, what you've got, the employer should say to the employee, well, we believe we've got evidence to suggest you've been bullying this colleague or whatever. The employer should explain carefully to the employee what the issue or performance issue is, go through the evidence, and as we've been saying with the grievance procedure as well, there should always be a second person there to make sure that somebody is taking notes. And at the disciplinary hearing, the employee gets the chance to sort of set out their case. What they say, well, I don't bully this person, this is what happens, answer any allegations, ask questions, and they might have evidence themselves. If for instance, the employer is saying you send abusive messages to your colleagues, and has got evidence of those colleagues' abusive messages, the person who's the subject of the disciplinary might go, well, actually, yes, sometimes maybe I have sent abusive messages, but here's my evidence of the abusive messages that these colleagues have sent me, which is why I've sent abusive messages back. So that's the type of thing you need to consider. You're looking at all the evidence that you have got. Doesn't happen terribly often in disciplinary hearings that I have been involved in, but you can call witnesses. I think that that does rather protract the matter and does rather put the witness on the spot. But it is possible, if the matter, I suppose, was sufficiently serious, you could have a witness to come along and sort of give kind of oral testimony. So, for instance, if it was to do with matters of behaviour or whatever, you could ask this employee, the employer could ask questions of this witness at the time. But I must be honest, my preferred practice is to give statements out, because I think it's very difficult for the witness who's been dragged into this meeting, which they're only a witness and doesn't directly concern them. So if we go to the next slide, yep, thanks. Once you've done your disciplinary hearing, it's a good idea for the employer to take some time to consider carefully making the decision. Absolutely document that decision-making process. The employer should tell the employee what happens next and give the person a time frame, and take a written confidential record of the hearing. If you've got a disciplinary matter, say for instance, it is, one of the more less serious ones that would only maybe merit a written warning, you would write to the employee after saying we're giving you a written warning, and you might also want to give them some general bits and pieces of advice about their behaviour going forward. You might say, on this occasion it's a written warning, but we expect your behaviour or conduct to improve. If similar behaviour happens again, you might get more than a written warning. And in fact, if it's so sufficiently serious, we may decide to actually dismiss you. So a point to take on that. Telling the employee the outcome, again, similarly with the grievances, you shouldn't deliver. Certainly, I suppose the employer should tell the employee the outcome as soon as possible and in writing. Yes, that's the case. I mean, obviously, if you're dismissing someone for gross misconduct, you might often at the time simply have to tell them verbally that they're being dismissed immediately for gross misconduct, but you should always follow up in writing. A disciplinary decision somewhere along the lines there should always be some follow-up with it in writing. So if the employee's conduct or performance has not improved in the time frame set, you can repeat the disciplinary procedure as well. Never very desirable, but obviously an option open to there. Go to the next slide, Natasha. Thanks. This is the sanctions that are available. I mean, you can give for low level, for instance, if you've got an employee who's been walking in 5 minutes late every day, you can give them an informal warning as a sort of very low end disciplinary matter. The next slide, Natasha. Thanks. More serious would be something like a written warning. I have kind of set out what the written warning should say. It should obviously say, if there's got to be change, what the change is and when it should happen. And obviously, if it is something that's sufficiently serious or possibly behaviour you fear will repeat itself, you might say if it doesn't improve, whilst at the moment we've given you a written warning, we might subsequently take further action or more serious actions later down the line. I think we'll jump this one as well, Natasha. Thanks, and just go straight on to dismissal. So this is obviously for the utmost serious disciplinary offences. You might decide that the only course of action open to you as an employee is to dismiss the employer, to dismiss the employee. In these cases, dismissal would be for one sort of serious offence. That would be something like gross misconduct. For instance, turning up at work under the influence of drugs or alcohol, or stealing money, or very serious. Often, certainly, if you're using our style template employment contracts, we in those give examples of what we consider to be issues of gross misconduct. So for something as well, like maybe a significant serious health and safety breach or something like that, might also be gross misconduct. Another reason why you might dismiss the employee is if you've got repeated instances of this behaviour. So we've touched on that already today. If, for instance, you've had to say, for instance, it's maybe very low end, I mean, I suppose it wouldn't be called bullying, but say, for instance, there's evidence to suggest that your behaviour towards a colleague hasn't been as maybe as good as it should be, and they got a written warning or a final written warning this time. They if the behaviour repeats itself, you can make reference to that final written warning and say, this time we're taking the more serious action of dismissal because you're effectively a repeat offender. And an important point, but I suppose it's probably sort of very obvious, but unlikely it's going to happen any other way. Dismissals should only be decided by a manager who's got authority to do so. So, I suppose it's unlikely that the church secretary is going to dismiss the organist, but I suppose just important to make sure that the person who is doing the dismissal is obviously of a capacity and of a standing to actually do that themselves. Similarly, with grievances, the important point here again is about a right of appeal. When you give when someone is dismissed for gross misconduct or for repeat offending at lower level, they have to be given a right of appeal. I mean, a right of appeal is not a statutory requirement, but I would always say to people, give them the right of appeal. Certainly, if you go to an employment tribunal and you've not given the person the right to appeal a decision of gross misconduct, you are putting yourself, I think, at quite a significant risk that an employment judge might say, was this procedure you followed a fair one? Should you not have given them the right to appeal? So yes, I think always make sure that is included as well. Right of appeal. If an employee's got a right of appeal, obviously they have to have what we determine as appeal grounds. So, for instance, the appeal grounds, are the outcomes too severe, i.e., an example of that might be I was dismissed, I should only have been given a written warning, that wasn't appropriate, and also if they think the procedure was wrong or unfair. For instance, an example of that might well be as if you simply for instance, you heard that if someone came to you and said the church organist has turned up today and is under the influence of alcohol or drugs, and you didn't do any investigation about it, you just went up to the organist and said you're dismissed, that might well be unfair. You've not carried out any fair process, so you need to make sure you do that in terms of the appeal as well. And last but not least, obviously keep notes, keep records. Those of you who have been through disciplinary processes or whatever, if the employee is dismissed or there's anything serious, you will find that there probably will be 3 or 4 weeks that not much will happen, and maybe you think it's out of your life, and along then comes an employment claim or something like that. So do retain all the relevant information you've got. You will be more than grateful that you did when it comes to defending any potential employment claim you've got. This last point is very, very, very small point about data protection law. I think the data protection law in relation to these things is keep these things for 6 or 7 years is the kind of prescribed length. I mean, I would have hoped really that that there wouldn't be a huge requirement for it to be kept for much more than really a year or whatever. But certainly in the interim period, don't dismiss. I mean, what I wouldn't do is simply dismiss this difficult employee, have a shredder party, and just put everything in the shredder the next day, and then suddenly 2 weeks or 3 weeks down the line you've got a claim and you've not kept a copy of your paperwork, because that puts you in a very difficult position. So that is me on to any questions. Been a bit of a whistle stop on grievances and disciplines. Obviously, reiterate again that I am here and more than happy to provide anyone with any advice they have in relation to these matters. The slides themselves in this particular session have been quite heavy, I appreciate, in terms of wording and everything else, but hopefully if you are at least initially, if that type of thing where you're initially faced with a matter, you'll be able to pick up the slides and just kind of get a few pointers as to what you want to do, rather than get anxious about what your steps are, and then once you've maybe looked at a few things and come to maybe investigated, please get in touch with me, and I can obviously help you and support you through the process. So thank you very much, and thank you very much just generally to all of you who have given up significant amount of your time over the past 4 sessions to listen to me rabbiting on at you about employment. Hopefully it's been helpful, and if there's any other bits that people, or if people do have, I mean, any general queries or any queries about, or things they would like further things on, obviously let me know. I think it's been a really helpful and useful exercise to do as well. It's been good to see so many people coming on the calls and being supportive and very interactive. So thank you all very much. If anyone's any questions, though, I'm happy to take those.
I have two.
Oh, fire away.
I think they're pretty straightforward, and I think one of them you probably already answered. The first one was to do with grievances, and and when you were talking about what happens when you're dealing with a situation where it's a he said, she said kind of scenario. One person saying, "Well, this person said this," and the other person who's got the grievance, whose grievance has been made against him says, "Well, actually, no, that's not what happened." What would be the best form of attack? Form of attack, that's not the right word at all. Form of approach. Would a mediatory approach?
I mean, that might in the circumstances be quite helpful. These are always very difficult ones where it's a he said, she said scenario, and I think probably from the employer's point of view, Alien, the important point I think is to think, and I mean, it's the type of thing is, it sounds kind of stupid to say it, but looking beyond the grievance, because obviously at the end of the day, he said, she said, irrespective of how your decision making is going to work in that particular case, these people are going to presumably have to remain working together. And I mean, in that particular scenario, if you feel a mediatory approach might be helpful, then I would totally recommend you do it. I mean, I suppose the difficulty is that the person who's raised the grievance might not be happy with that. But equally, the difficulty is if you investigate the grievance, you might not, on balance, think that the grievance is upheld, and then they might be unhappy about that. So I suppose it's always the thing with mediation that hopefully people can work together to try and get a resolution that kind of fits everybody. Because with a he said, she said, it's you are in a very difficult situation where if you've got two compelling accounts, one person saying that happened and the other person saying it didn't happen, you would have, I think you would have to be very certain that if you're going to uphold the grievance, that you preferred that account over another, and it is very difficult. So maybe in those instances, yes, a mediatory approach is better, because hopefully if you mediate it, it will it will come as a, the person who's raised the grievance will come out of it satisfied. The person who's sort of effectively the perpetrator will, be happier too. And obviously you as an employee will not have a difficult situation where, you've got two unhappy employees because of something you've had to make a decision on. And at the end of the day, I'm not suggesting it was a heads or tails, but to a certain extent, you really, you're sitting reading it and you're kind of thinking, how am I going to decide this? Because actually I find both accounts quite compelling. But I mean, if you are faced with that at the moment, or you want to have a more, formal chat, or let me know, please get in touch about it. That's a particularly difficult kind of grievance to be in, where it really is a he said, she said scenario, because obviously the law in relation to the person raising the grievance suggests that you've got to follow this fair procedure and you've got to do things. But equally, I suppose if it's a he said, she said, it might well simply be a case of this one person simply got in quicker to raise the grievance than the other, if it's a long-term problem. So yes, if some kind of mediatory approach would be helpful, and also notwithstanding the fact that these people are potentially going to have a future working relationship together, it's always difficult when you kind of do these processes. I suppose what you're trying, I mean, at the end of the day, you as the employer have got to be fair, but equally, I suppose you're thinking, well, hang on a minute. I mean, if I take the grievance raising person's side over the other person's side, the person who maybe had a, the he said, she said scenario, who thinks, that's not very fair, it's going to make the whole working environment quite difficult. So yes, absolutely, mediation is in these circumstances incredibly helpful.
Mhm. The other question I think you've probably already answered is in relation to summary dismissal or I was wondering, sorry, or suspension actually. Would you in the first instance suspend somebody until you've done the investigation,
Yeah.
even under gross dismissal?
Mm, is the answer. And
Okay.
actually, thank you for bringing it up. This suspension. Actually, I curiously did not mention it in the slides. I mean, suspend. It probably should have. So, note to myself. I mean, suspension is very much. It depends, I suppose, on what the allegation you've got is. If you have got an allegation of, I mean, I suppose taking a very rudimentary example would be if it was a harassment disciplinary
Mhm.
matter where potentially there was a sort of especially with something maybe like a sexual harassment matter. I mean, you can suspend an employee pretty much as soon as the allegation comes to light. Suspension is not in itself deemed in law to be punitive, and the person who's suspended would obviously be on full pay until the matter is investigated. So yes, I mean, if even if you were doing even if it was a gross misconduct matter, you would suspend the person whilst you're conducting the investigation. I mean, it's much more likely, I suppose, you're going to suspend someone where it's an allegation of gross misconduct, because
Mm.
obviously gross misconduct is the most serious nature, and that would be something where probably serious or more serious things like sexual harassment fall into. I mean, suspension is largely Aileen within the gift of the employer. I would suppose I would just say just use it. It should be used appropriately. I mean, if it's a serious bullying allegation, there could be other ways around it. I mean, if it could be arranged that I had a situation in a previous role I worked in where it was two lady paralegals who one of them claimed one was bullying the other. And I mean, some of the points she raised on paper anyway seemed to be really quite serious allegations of bullying. But and I mean, I think if the circumstances hadn't been a little bit different in this case, we probably would have had to suspend the person accused of the bullying. But actually, what we managed to do was, because we worked on two floors, we simply put the person who was being accused of the bullying on a different floor. So actually, they were able to do their job, because obviously at the end of the day, we needed them to work. There was nothing wrong with the work they were doing, so they were able to do their job. So there's that type of thing you can do as well. You can just maybe not have them sit together, have any interaction. But I mean, obviously, if it is very, very serious, yes, go down the route of suspension. I mean, as I say, suspension in the eyes of the law is not supposed to be. I don't know whether it's a sort of hold back of that whole school thing of being suspended makes you naughty. In employment contexts, suspension is really there as a sort of protective measure. It's certainly, if you're suspended from your employment, that is no assumption should necessarily fall from that you will lose your job. It's just in the circumstances of balancing fairness to the employer and the employee and the person who've raised the grievance or the matter.
Mhm.
That it's better that they're not at work. I mean, I suppose within in the context in which we work now, it might well be that you could have that person simply work from home or remotely for a bit of time as well. We've got so many more options now, with the way kind of the working world has evolved post COVID, how to deal with these things. So that's another option too. But yes,
Mhm.
suspension is very much within the gift of the employer to do anything they want.
I suppose what I was thinking about in particular with that situation was, for example, if someone were to come into work under the influence of alcohol, but it hadn't happened before, and you were concerned about extenuating circumstances,
Mhm.
technically it's gross misconduct.
Yeah.
But is there any situation there where you might want to investigate a bit more to see and offer time for that behaviour to change if it's been if it's been out of the blue and you think
Yeah,
there
yeah,
may
no,
be
no,
some.
it is. I mean, I have had a few issues, within the church of where, I mean, I'm saying, but by no means suggesting it's solely
Mhm.
related to do with a couple of cleaners who have come into churches, and there's been suspicions that that they have been, that they are under the influence of alcohol, possibly if they're just having difficult things in their personal life. I mean, probably in those circumstances, I mean, what might be sensible would be to, well, assuming it's possible. I mean, obviously, I'm saying this, but if the person is severely under the influence of drugs or alcohol, it might not be very easy to have a conversation with them. But possibly, if they are just giving off, I mean, if they are apparent, if they are seemingly sort of maybe intoxicated, or possibly, if they've finished their drinking at 3 in the morning and they're turning up at 8 o'clock in the morning, so they're not possibly as intoxicated as if they were doing it at the moment, but clearly, you wouldn't want them driving a car or whatever. You could maybe have a conversation with them and sort of, in those circumstances, it might just be appropriate to say to the person, go home at that point. You could do a little bit of investigation. You could suspend them thereafter. I think with all, I mean, I suppose caveating it all, Aileen, employment law matters. The word fairness is the name of the game, really. And I think provided you're able to show in whatever you do that your thought process behind it has been fair to the employee, it's very unlikely that an employment tribunal is going to interfere in that. If you can show that you've followed fair procedures, that you've not. I mean, say hypothetically, a cleaner comes in to work in the circumstance I've described. She's obviously been drinking, very late in the morning, really not very appropriate. Coming in possibly smelling of alcohol, or she is possibly still a bit drunk and not maybe in the best state to do her job. It might be unfair in those circumstances to immediately dismiss the employee, but you would certainly be within your rights to send her home and then maybe have a follow-up discussion with her after. In that time, you could do investigation. I mean, you could, I suppose, speak to other people in confidence, if there's someone who maybe is another sort of senior role or whatever to you, and sort of say, look, so and so came into work today. She appeared to be intoxicated, or certainly had been drinking heavily the night before and wasn't in a fit state to do her job. Have you ever come across these? Are you aware of any previous instances or whatever? So you are kind of doing investigation, and if you keep a note about that. So, but I mean, yeah, that is quite a sensitive matter, and suspension as well is quite sensitive, Aileen. So absolutely, if you're faced with any of these, please just pick up the phone or email me or whatever, and I'll happily help you out. But in general terms, with these things, with grievances and disciplinaries, really, as the employer, what you are looking to do is just make sure you're being fair. I mean, the word fair is one of these words. What's fair to one might not be fair to another, and how do you know? But I mean, I think it's so long as you're able to show that you are being fair, and you are doing, you're looking at things, dealing with things, not jumping to conclusions or whatever. It is very unlikely that an employment tribunal is going to find that the employer's conduct is unreasonable in taking whatever action you take, provided at least on paper you seem to have followed something that seems fair.
Okay, thank you very much.
Not a problem.